Welcome, everyone. Thanks for joining us on time. We're going to try and keep to a tight schedule. In the next hour, we're going to have our first panel, and that's called, it's entitled Decrypting Crypto, and that's the policy, security, and regulatory challenges. It's going to be moderated by Kiran Raj. I'm just going to give you a very brief background on Kiran. He is the Chief Strategy Officer for Bittrex, and you've heard all about Bittrex. He's also a professor here over at the George Mason University School of Law. He teaches national security, surveillance law, cybersecurity law, and just to give you some of his background, he's been at the Department of Justice. He's been a very high role at DHS, and prior to all that, he was a program manager over at Microsoft. He's a patent holder, so he's also got a very strong background on the technical side. I'm going to kick this over to you, Kiran, and take it from here.
Great. Thanks so much, and thanks, everybody. Very excited to have this panel. We've got a very distinguished group of individuals, and I'm going to go quickly and introduce them. So I'm going to start all the way down at the end with Brett McIntosh, who's the General Counsel of the U.S. Treasury Department. So to put that in sort of layman speak, he's the top lawyer at the Treasury Department. He's had a very distinguished career. He's a partner at a large law firm called Sullivan & Cromwell. He's worked both in the White House and in the Department of Justice in previous administrations. To his left is Jamie McDonald. Jamie is currently the Director of Enforcement at the CFTC. So again,
two to the left.
Sorry, two to the left. Sorry. Oh, you guys
So we switched it up. We switched it up on you.
Sorry. So I'm going to jump around a little bit. So this
keep you on your toes.
And he's the Director of Enforcement at the CFTC, which, so again, in plain English, he's the head of the Enforcement Division of the CFTC. Before that, he served as an Assistant United States Attorney in the Southern District of New York. He's clerked for Chief Justice Roberts. He's also served in the White House Counsel's Office and at a law firm called Williams & Connolly. Now in the middle is Jameson Seitz. Jameson is the International Tax Manager in the Washington, D.C. office of a firm called RSM, which is an international accounting and advisory firm. They do a lot of work in the blockchain space. A lot of folks know them for their work here, especially around tax, and Jameson's going to walk us through some of that. He was also an Associate General Counsel at the Berkeley Research Group, which is a leading strategic advisory and expert consulting firm. So we've got a great group, folks who've got a lot of knowledge in this space. We're excited to hear from them. And so what I thought we'd do is start a little bit with the basics. And so I'm going to turn to Jamie to talk at a very high level, what does the CFTC do with respect to blockchain technology? What's the CFTC's jurisdiction? And what does CFTC stand for?
Thanks, Peter. So even before I can say what the CFTC stands for, I have to give the disclaimer that these comments are mine. They're not that they don't reflect the position of the Commission or its staff. So the CFTC, we regulate commodity futures and other derivatives like swaps or things like that. And in the virtual currency or blockchain space, I think one thing that's important to remember about our jurisdiction, one thing that's important for market participants to understand, is we have a difference in our jurisdiction between our enforcement jurisdiction and our regulatory jurisdiction. So our regulatory jurisdiction really is focused on the derivatives markets. So in December of 2017, the Commission allowed to be listed 2 Bitcoin futures contracts, one at CME and another at CBOE. There's a Bitcoin swap. There have been other Bitcoin derivative products that have been listed prior to CME and CBOE's listing of Bitcoin futures, though the Bitcoin futures listing in December of last year was probably the most high profile or the thing that garnered the most media attention. So our regulatory jurisdiction, which is to say the jurisdiction to require exchanges to do certain things, require certain margin modeling or margin requirements, require cybersecurity to be up to a certain standard. All of the types of things that would be you typically think of with respect to ensuring or protecting market integrity and protecting customers who are involved in these markets, That's our regulatory jurisdiction, and it really is limited to the derivatives, the futures, the swaps markets. We do not have regulatory jurisdiction over the underlying virtual currencies or blockchain more generally, from a regulatory perspective. From an enforcement standpoint, we do. Our enforcement jurisdiction is broader than our regulatory jurisdiction, and our enforcement jurisdiction allows us to police all commodity markets, all commodities that are traded in interstate commerce for fraud and manipulation. And so one of the things that we've done in enforcement is we've been looking very closely, and we've been keeping a very close eye on the underlying virtual currency and blockchain markets, to the extent, in particular, that they feed into the futures market. So our primary focus as an agency is on the derivatives markets. Though you guys will know this, but one way, if you wanted to manipulate, if you had a manipulative strategy to manipulate the derivatives market, one way you might do that is to engage in trading activity in the underlying cash or spot market. So if you wanted to manipulate a Bitcoin futures contract, that Bitcoin futures contract bears some relationship, and the relationship will depend on how the contract is drafted, but it bears some relationship to the underlying Bitcoin commodity itself. And so depending on the relationship, you could engage in some trading in the underlying that would affect the futures position. The futures position fits within the core of our regulatory jurisdiction, so it makes good sense then that we would have enforcement jurisdiction over the underlying. But one of the things that we've done is to try to make clear in the customer advisories, in the different guidance that we've put out, that from a regulatory standpoint, to the extent that market participants are involved in transactions in any of the virtual currency cash markets, we are not primary regulators of those markets. And so we do think that there's an additional level of diligence that needs to be done, both whether you're talking about a platform, a market participant, or a customer who's involved in that in the activity.
So if you had to describe your enforcement priorities of the CFTC, would it be sort of price manipulation that would affect the derivative or futures market, or how would you describe your priorities?
So we're really looking at it on a few different levels. First, we're looking at the activity on the derivatives exchanges. So to the extent that there is any on derivative exchange, so spoofing on the CME or a manipulative strategy on CBOE, we are getting that data in, we're analyzing that data on a daily basis, and we're looking very closely at that. We're also looking at the underlying cash market. In particular, you're right, to the extent that it feeds into the futures price, although the relationship between the underlying cash, any potential manipulation of the underlying cash market and the futures contract isn't always going to be apparent at the very beginning. And so our jurisdiction is not, the enforcement jurisdiction is not limited, doesn't require us to show a nexus between the cash and the futures contract. And our view has always been, yeah, one reason that we look at the underlying is to ensure that the price discovery process and the futures contract or market is one that we can have confidence in. But if we see manipulation in the underlying cash market, or we see fraud in the underlying cash market, we have jurisdiction. I don't think it's an answer to say, well, it doesn't feed directly into the futures contract, so we're not going to pursue it. But the third level is on the retail side. And I do think it's important that we have an active enforcement program with respect to retail fraud in the virtual currency or the digital asset markets, in part because big picture, one goal of the CFTC is to ensure that we are facilitating and not hampering market-enhancing technological developments, particularly in the fintech area. Although it's important that that be balanced, and that it be balanced. If you do things the right way, then we're gonna work hard to make sure that we're facilitating market-enhancing activity. But if you do things in the wrong way, we're going to make sure that we're policing those markets, so we're looking carefully at them, and that we're as vigilant as we possibly can.
I want to move to Brent for a moment. So the Treasury Department is a fairly large organization, a lot of divisions, a lot of different agencies. It might be helpful just to sort of set the picture with the audience to explain, what are the sort of key divisions within Treasury that where there's some nexus to the blockchain industry.
Try and turn on my lapel mic without deafening people. So Treasury
has 3 places where, or 4 places really, where we touch the cryptocurrency and blockchain spaces. And then another one where we play a convening role for the rest of the federal government. So to think about what Treasury does, Treasury has we have 3 big undersecretariats. One of them is domestic finance. And our domestic finance people are charged with regard to cryptocurrencies and blockchain, and thinking about how does this fit into the financial system? How does it fit into the US financial system? And of course, the US financial system is integrated into the global financial system. How should we be thinking about the great advantages that could be gained and the downsides on a conceptual level? We then have a terrorism and financial intelligence undersecretariat, which thinks about this in a quite different way that is integrated with what our domestic finance people do. And they are thinking about it in terms of how do we prevent cryptocurrencies from becoming a safe haven for illicit activity. That's what they do with regard to all sorts of different currency transactions, and they do it with regard to cryptocurrencies that are registered on the blockchain and all sorts of different kinds of, I mean, they're looking at across anybody who touches the U.S., basically. So they have the money laundering and the countering terrorism financing mission within Treasury, and they are looking at it from that perspective. We then have an international affairs undersecretariat, which is engaging with our foreign partners on these questions, because the United States is at the forefront of thinking about a lot of these questions. In particular, we're way ahead of most other countries when thinking about how AML, money laundering obligations, would apply here, and we're trying to bring along the rest of the world so that even if we're preventing illicit financing from finding a safe haven in this space, our foreign partners will as well. And then, of course, there's the big elephant in the room when it comes to Treasury, which is the Internal Revenue Service, which thinks about the tax questions. Treatment as an asset, capital gains treatment, things like that. And then we play a separate role as the convener of other government agencies, and in particular, lots of independent agencies like Jamie's, the SEC, the financial regulators as well. And so my boss, Secretary Mnuchin, chairs the Financial Stability Oversight Council. We're involved in a number of other interagency bodies where we pull in regulators and others, the Justice Department, to think about how, as a government more broadly, we should be thinking about what is a new technology and how certain old principles ought to map onto that technology, and where those principles should give way or be modified, and things like that. Because if you'll excuse an example here, there's an old Indian parable which is memorialized in a poem by the American poet John Godfrey Sachs called The Blind Man and the Elephant, where a series of blind men go up to an elephant, and one feels the side of the elephant, and he says the elephant's like a wall. Another feels the tusk of the elephant, he says the elephant's like a spear. One feels the leg, he says the elephant's like a tree. There's a danger that we do the same thing in the federal government, right? We say, Bitcoin is like a security. Bitcoin is like a commodity. Bitcoin is like a currency. And so we need to be getting together to think about how we map on certain old principles to what is a very new technology, and do so in a way that doesn't discourage as Jamie said, the advantageous aspects, but does do things like making sure that taxation works, making sure that we're preventing money laundering, we're not creating a safe haven for money laundering, making sure that, as Jamie was discussing, we as a government are thinking rationally about how do we engage in consumer protection with regard to these things. And if we don't sit down and think about it as a government, we're going to have a dozen different approaches. And so I think the Treasury Secretary, in part because he, in many cases, not actually a primary regulator, is the convener of many of these governmental bodies, is in a position to get people in a room and talk about how should we be thinking about this, and how should we be mapping out the jurisdictions of the various federal agencies and what are the places where we're not doing anything where we should and where should we be backing off. So, and I know that Jamie and I have both been part of those conversations, and they're in the formative stages, but we are attempting to move forward.
Well, that's a great segue into a sort of question I had for Jameson, which is that, from a private industry perspective, how do people define cryptocurrency? I mean, you hear the terms cryptocurrency, blockchain, digital tokens. Are they the same thing? And does private industry have a specific definition? Because it sounds like government's sort of working through some of these issues to the private industry as well.
From what we've seen, I think this is on. If you can't hear me, let me know. Obviously a lot of overlap. You have the underlying technology, blockchain, but our clients are seeing that you have different portions of the government defining it as different things. So I guess I have to look at it from a personal perspective versus how we view it in the tax world are a little different. Personally, blockchain, the underlying technology, you had a great presentation earlier on kind of what that is. Getting into the difference between what is a token, what is a coin, where maybe the coin is the medium that runs a specific blockchain, and a token maybe references something that rides on top of it. You'll see most of the ICOs coming in broadly considered as tokens. It's a new and evolving space. I think you have a lot of misnomers out there. I think cryptocurrency can generally be referred to, generally references the whole gamut of coins and tokens, despite its inclusion of currency in the name.
Oh, sorry, go ahead.
No, so from the tax side, all we have from Treasury, unfortunately, from IRS, is a notice that was issued in 2014. So that's already dated, right? And they treat it as they have a tradable virtual currency. So they don't use any of these terms. And specifically, the notice, if you want to read it narrowly, it really only refers to those that want to be a currency. So if you're thinking in the world that we're in, that doesn't really apply to a lot of the tokens that are being as ICOs, because they are more intended to either be something akin to prepaid services or perhaps to just a real ICO that's really trying to be an equity stake. So you look at that notice as the only guidance, and maybe that's Bitcoin and Litecoin. So okay, great, now we know what some of our traders or Bitcoin miners, we can kind of figure things out by analogy. And in the tax world, it's property. That's the main takeaway from the notice in 2014 is that, okay, so now we can track it. It has to be tracked in USD. If you're paid with it, that's compensation. So that gives us a vast amount of case law. I mean, nothing here is I don't want to say nothing here is fundamentally new. Blockchain is fundamentally new, but we're able to figure out the tax consequences by reference until we have clear guidance of whether or not it is a security. Because if it is a security, then it can be traded on a registered securities brokerage exchange, which means you can then take mark-to-market rules. Right now, we can't. So I think as it evolves, I'm hesitant to have regulation come out and define it before it really defines itself. And I think they're taking the smart approach of saying, we're going to let this evolve. And I think that's a great approach, but it leaves some uncertainty. So that unfortunately means that my services are in demand for determining, coming up with opinion letters.
That's unfortunate. Why is that unfortunate?
Unfortunate for everyone else that I am in charge. That's kind of where we are in the tax world. A lot of big question marks, a lot of figuring out by analogy. What is in the ICO space? We do a number of ICOs. So when we bring them on at our sim, we actually put them through an SEC background check as any of our SEC clients. So they, all the founders have to be background checked before we bring them on and advise. We also, means-based their idea and feasibility, et cetera, because we don't want to be put on the hook for something going south.
Well, let me combine sort of two things. One thing you said and one thing Brent said, and then pose a question to Jamie. So it sounds like the government has a process in place where there's some type of convening to talk through these issues. And as Jameson said, a lot of these things they're evolving very quickly, right? A lot of different use cases, a lot of different ways of using the different blockchain technologies as we heard from the keynote speech earlier today. So, is there a process, is it this convening process that Brent talked about within government to work through these? Is there a way for private industry to plug in to help educate the government? How do you guys think about just the pace of innovation here is very quick?
So let me take a step back, just in answering this question. So Jameson, your point that nothing really is new here, or there's a lot you can do by analogy, I think is something that applies equally for us. I mean, the idea that there are markets that have overlap, for example, between the CFTC and the SEC is not new. We see it in the VIX, we see it in the Treasury markets, we see it in all sorts of markets where some part of that market is regulated by the SEC and some part of that market is regulated by the CFTC. FinCEN is involved, Treasury is involved. There are questions that are raised for the IRS. There may be questions that implicate other aspects or equities that the United States government would have. There's international regulation, and so we have a lot of processes in place that govern how we address those types of questions. And so in one sense, yeah, blockchain is new, and some of the issues that arise in the virtual currency context are novel issues. But the basic problem, or the basic issue of coordinating across the government, is something that I think, in order to be able to do our jobs effectively, we have to be able to do, and it's something that we really have as a top priority. A lot of it is through Treasury and through the coordination of folks like Brent and the FSOC process there. But a lot of it is direct coordination between the CFTC and in January we issued a joint statement with respect to virtual currencies where we laid out some of the ways that we go about thinking about whether something is a commodity or a security. And one of the key points, I think, is that we're gonna do it on a case-by-case basis on a digital asset or virtual currency, whatever you want to call it. We're gonna do it on a case-specific basis. And it's going to be a functional analysis. It's not going to be a formal analysis. We're not going to care what somebody calls the thing. We're going to look at how it's actually functioning and how it's intended to function and how the customers who are participating in those markets expect it to function. And from that perspective, I think I take the point that there's some fuzziness at the margin. But I do think that there's rough consensus that there are certain things that are commodities, certain things that are securities, and you have a regulatory structure that's starting to be built around them. And there's a real logic, I think, to that regulatory structure. When you think about the difference between the securities markets and the commodities markets, and you think about the difference between the way that the securities regulations have been written and have evolved, and the commodity regulations have been written and have evolved. And you look at, so take, for example, securities. One of the things that distinguishes securities from commodities is information asymmetry. So when you're thinking about a security, you're typically thinking about some central party who has inside knowledge or inside information about the enterprise that's being run, and you have outside investors. In the commodities world, you really don't have that. And so what flows from that is a securities regulation regime that's largely focused on disclosure, it's largely focused on filings, and it's focused on the kinds of things that look at that information asymmetry and that try to regulate it in a sort of logical and coherent way. In the commodity space, that's not a central feature of the commodities markets, and so we have a more principles-based regulatory regime that's focused on other sorts of things. And I think you come at it from those different points of view, and I think, yeah, there are certain things that are clearly ICOs, that are clearly investments in some enterprise that are very clearly going to be securities. I think there are other things that are much more likely to not be securities under the Howey Test, and there are things at the margin that where the line may be a little fuzzy. And I think a particular challenge is something that may start out looking a lot like a security in some form of an ICO, and then once it becomes more, it moves from the nascent stage to more developed, is it actually operating or functioning less like a security and more like a commodity? I think there are going to be challenges in those certain areas,
But the bigger picture question is one that we're soliciting information and trying to make sure that we are as intelligent about these issues as we possibly can. So we're soliciting them from market participants. We're soliciting them from really the range of different market participants who may be involved in this space. We're constantly in discussions with other governmental agencies, and we want to make sure, and I think the public has a right to expect that there's a coordinated approach from the government's perspective. So it is something that we're working really hard to make sure that everybody's on the same page, that there's complete information sharing, and that we're working to get all the information to the right sources.
That makes a lot of sense. And for those who don't know, the Howey Test that Jamie mentioned was a Supreme Court case from 70 plus years ago that sets out 4 factors that you look through to determine whether something is a security or not a security. But on that point, so this sort of interesting concept that you talked about, which is something may start off looking a lot like a security, but then over time it looks potentially more like a commodity, and that's where I think there's a lot of questions and people are trying to dig into that. I mean, is that an area that you think the government just generally will be able to put more guidance out? I mean, I think one of the things one of your commissioners had mentioned at a recent blockchain conference that we shouldn't do sort of policy by enforcement, but we should be very proactive and really, provide guidance. And it sounds like that's in particular one issue that I know a lot of people in the private sector struggle with. Is that something that's sort of on the radar of governments, like let's put out more guidance?
Sure. So we have issued a number of different pieces of guidance, and I think we at the CFTC will continue to issue guidance on these issues. Now, I don't expect that we're going to be issuing guidance on every issue that this group has come up with, just because I don't think we're going to be able to move at quite that pace. But there's a balance. On the one hand, we want to make sure that we are responsible regulators who are, particularly where there are products that are moving into our market, like the Bitcoin futures contract that is directly regulated by the CFTC. I think the type of guidance that market participants that we should provide market participants who are operating in that market, that's probably at one end where it should be at its highest. At the other end are areas where we're not directly regulating, and there may be other ways that it comes into our space, but we may not be the direct regulator or the primary regulator. But to give you just one example, on the sort of the most guidance end of the spectrum, we had a case that was decided by Judge Weinstein in the Eastern District of New York last week, where we had filed a case, an enforcement action that involved fraud in connection with basically with a Bitcoin trading scheme. And we had sought a preliminary injunction. We filed this case at the end of January of this year, at about the same time that we issued the joint statement with the SEC. I think we actually filed it a couple days later. Judge Weinstein held a preliminary injunction hearing, and the CME filed an amicus brief in the case before the preliminary injunction hearing. Judge Weinstein ultimately granted the preliminary injunction, and he held that Bitcoin was a commodity subject to the regulation and the enforcement authority of the CFTC. But the CME filed an amicus brief where they explained, from their perspective, the reliance interests of market participants on the CFTC's consistent determination that Bitcoin was a commodity that could be regulated by the CFTC. All the steps the CME had taken to develop the contract, to get the contract listed on the exchange, the thousands of market participants who had then bought or sold those contracts, and the millions of dollars that were tied up together with those. And I think the point for the judge, and I think the point from our perspective is, as you move farther down the path towards regulation, I think our obligation to ensure that that the market participants' settled expectations are well informed and really are that these really are reasonable reliance interests. I think our obligation increases as we move forward on the regulatory side.
Makes sense. Well, I want to talk a little bit about some opportunities. So we've been talking about sort of government agencies a little bit as regulators, but Brent, do you see ways that blockchain technology can actually help Treasury and its divisions, like catch bad actors, for example, or have a better sense of money laundering, or some of these other areas? Like, is this something that, as a department, you're looking at the opportunities for blockchain as opposed to obviously the regulatory capacity?
Yeah, there are upsides and downsides to all these things, and we see, when it comes to, for example, take Jamie mentioned FinCEN, the Financial Crimes Enforcement Network, which is a part of Treasury. When we look at cryptocurrencies, we see a place where a huge amount of the transaction is anonymous, the transaction flow is anonymous, and so that makes us nervous. On the other hand, a lot of it is recorded, it's entirely recorded in the blockchain, so you can actually trace flows in a way that you can't trace them sometimes with cash or sometimes with other currencies, and you can trace them in an immutable way back to where they are. And then if you get to the, if you get to a place where you actually can determine who holds that wallet or whose account this is, then actually it does create a remarkable set of opportunities for us in quashing and discouraging money laundering. So we see opportunities as well as dangers. And I mean, to Jamie's point about how we think about issuing guidance or regulations, the federal government owes people clear guidance, not just in this space, but in any space. On the other hand, the federal government is not particularly agile, and when it puts out guidance, that guidance tends to be static. And we don't want to be in a place where we've not given guidance where it ought to be given. We also don't want to be in a place where we put out guidance that stunts advantageous technologies or directs development in a way that is harmful. So we have difficulties on both sides of that.
Well, maybe Jamie, same question to you. Like, what opportunities does blockchain technology present to help promote the CFTC's sort of regulatory mission?
So I think the answer from the CFTC's perspective is we are very much right now looking at it from the perspective of a regulator. I think we very much appreciate that there is potential for the underlying technology to have real market enhancement benefits. So one of the first things that our chairman did when he became actually acting chairman is we set up what we call Lab CFTC, and it's part of our FinTech initiative. It was almost a year actually before the first Bitcoin futures contract was presented to the CFTC by the CME and CBOE, and I don't think anybody even knew at the time that these two contracts were going to come before the agency. But the chairman was looking around the corner, and he was trying to think, okay, what are the major issues that are likely to come up, and how can we make sure that we're prepared to address them and to handle them? And so we brought in a chief innovation officer who's the head of Lab CFTC, who staffed out the Lab CFTC effort. They've had office hours. I expect some of the folks in this room have come to meet with them. But the point of these office hours is we've had them out in San Francisco, in New York, in Washington, D.C. We've had them all around the country. Is to try to make sure that we are understanding from the market participants, one, what a sound regulatory regime would look like. Because we think that you guys don't have the final say in that, but you guys are obviously a relevant constituent. We want to make sure that because you guys will be living with any of the regulations that ultimately, you guys are going to be living within the regulatory ecosystem, we want to make sure that we have all the information that we possibly can have. But we also are learning about what's happening in the blockchain world. So I don't want to I don't want to be specific about this, but there's one particular example that I can think of where we are using a technology that we learned about something that I think could potentially be very significant for, in particular, our enforcement efforts. And so, we very much appreciate that on one hand, we're the regulators. On another hand, we're the enforcement arm. And so the posture with respect to the particular market participants is very different when the regulatory world or in the enforcement world. But we're also, whether we're on the regulatory or the enforcement, whether we're wearing either of those hats, want to make sure that to the extent there's market intelligence out there, that we have access to it. We want to continue to bring as much of that into the agency as we can get. And in at least this one instance that I'm thinking of, we learned about something, we thought that could really help us fulfill our mission, and we went out and went out more.
But I will say, the lab CFTC has gotten some great reviews from the private sector. I think they really enjoy the idea that you can go in and have frankly a frank conversation. So I think it's been good both ways. I want to return to tax for a moment because people tend to care about that. Jameson, the tax bill that was passed at the end of 2017, are there specific provisions in there that folks here who might be investing in cryptocurrencies or digital tokens should really be thinking about? Maybe some specific changes between the 2017 regime and what we can expect for 2018?
For your average investor buying into cryptocurrency, there really is no change. By and large, I think a lot of it is a misconception or a rumor that was spread online by some people that are really hopeful that in some way they don't have to recognize this amazing amount of gain that they have. So you hear a lot of people saying,
Unlikely.
Oh, I'm going to apply like-kind exchange. So like I said, the only guidance we have from the IRS is that it is property and that it is not a currency. We get a lot of miners or traders coming to us saying, hey, I thousands of transactions a day. I went from USD into Bitcoin. From Bitcoin, I bought Ethereum, and then I didn't really want to go Ethereum back to Bitcoin, so I went onto the Ethereum market and got into Dogecoin or something like that. And we have a frank conversation with them, and generally we'll start and say, look, like-kind does not exchange, does not really apply. That's the biggest change from the tax reform, is that they have made it clear that like-kind exchange only applies to real property transactions, not real estate.
So basically, if you're making lots of money, use common sense, you probably owe tax. Is that the bottom line?
You have to trace your basis in U.S. dollar. So I mean, going forward, you look at what you're investing in. Make sound, safe, smart investments. Track your basis. It can be really difficult, but gold can't be like-kind exchange for silver. That's generally where we start, and then a lot of people just think like-kind exchange. I think it's kind of like that. I think of the Office episode where Michael declared bankruptcy just by yelling it. There's actually a complicated form where you have to disclose all of the transactions in which you're trying to assert like-kind exchange for. So it's, the detail there. When we talk to the investors, a lot of times we say, look, when you're looking into your, the exchange that you're doing these transactions on, can they provide you a good log of the transactions for which you can actually compute your tax basis and understand this? You guys are good, but Binance only allows you 3 months of transaction history. So unless you're pulling that every quarter, at the end of the year, you're kind of SOL. Unless there's some good third-party vendors that give them API keys, that's a risk. They'll help track your trades and compute a tax basis for you. So that's the biggest change that we see from an investor and innovator standpoint. C corporations are now kind of the new fad with the new lower rate, the limited drawback on our worldwide taxation system. We're starting to see that a lot of investors are saying, okay, I can actually use a U.S. C corp as a foreign holding company in terms of financial flow, management of money. In a few instances, we still do see that there are some marginal benefits to establishing and moving to Ireland. It's not, the outbound and inversion transactions are not completely shut down. They're, depending on what state tax you're trying to talk about moving, if it's well developed or if it's still kind of in the heads of the founders. There are still some plays in terms of moving it to other jurisdictions, but from a client perspective, we're seeing a lot less risk-taking. The Apples and stuff have been kind of beaten up in the press for some of their tax planning in Luxembourg and Ireland, so a lot of clients don't want to be the next one on the front page of the Wall Street Journal, so they're taking a little bit more of a scaled-back approach, not as aggressive. So by and large, our clients are welcome using U.S. regulations to give them some clear guidance and really clarity and security in their business decisions towards driving a lot of planning right now.
Great. Well, you mentioned Binance, which for those that don't know is an exchange that's overseas. It's not a U.S.-based exchange. And Brent, you mentioned earlier that you have an undersecretary of Treasury that focuses on international issues. And so, I'm curious, how do you think about the international impact of the decisions that you guys are making in the government today? So one of the things that was talked about a little bit during the keynote was, if you look at just the last 6 to 9 months, there's been actually a lot of capital flow, a lot of innovation that has unfortunately left the United States and gone overseas, and in part because there's this sort of regulatory arbitrage where there's some jurisdictions which, for whatever reason, aren't, certainly don't have the enforcement zeal that other jurisdictions have, or just basically letting a lot of things go. I mean, how do you guys think about that when you're working with foreign partners?
Yeah, so we work really hard to get these things on the agendas of the various multilateral international organizations, whether it's IOSCO or the FATF or the G20's finance ministers are meeting next week in South America, and we put it on the agenda there. We feel strongly that in these organizations, the U.S. ought to be a leader in driving policy because we tend to think about these things in a way that leads others to follow us. And so, for example, on AML, we and the Australians, and I think the South Koreans and maybe the Japanese, are kind of at the forefront of thinking about how the old AML rules ought to apply here, and that's not going to work if we can't bring others along with us. And so one of the things they'll be talking about at the G20 next week is how do we get those money laundering rules to be enforced broadly by other countries. Now, it's one thing to do it in the crypto space. We've already done that with regard to the non-crypto space. We really were the leaders in bringing along other countries on money laundering and on countering terrorist financing, and we want to do the same thing here. So, I think we're looking to lead in that space, but we do want it on the agenda.
So before we open up for Q&A, maybe one final question for folks is, if you could wave a wand, maybe I'll start with you, Jamie. If you could wave a wand, what aspects of the blockchain industry would you want to change in order to minimize some of the challenges to your agency and the industry that you guys regulate, while at the same time preserving some of the benefits of the innovation of the space?
So not to resist the question, but I will. I guess I will resist it only to say it's not about us as regulators waving a wand and saying what we would change about the industry, but I do think we have a role to play, and this is why I started talking about the difference between our regulatory jurisdiction and our enforcement jurisdiction. When there are market participants who are seeking to avail themselves of something that fits within our regulatory jurisdiction, then it may well be that there are certain things that we require. So if there were a virtual currency that allowed truly anonymous trading in the derivative space, and we would think long and hard about whether that's the kind of thing that we could regulate that would not be readily susceptible to manipulation. And I do think that there are going to be things, particularly if the virtual currency market or other components of the blockchain industry extend into the derivatives market, which is regulated by the CFTC. I think as that universe grows, there may well be specific things that the agency is thinking about and is requiring that may not be present across the blockchain industry now. There are certain types of coins or tokens that I think present particular issues. from either an anti-money laundering perspective or know your customer, the kinds of things that to have a CFTC regulated exchange list a particular product, there are certain things that we're going to require. And so it's not waving a wand, but I think it's if you want to be part of that market, then you have to meet these basic requirements. Now, if you don't want to be part of that market, I'm not going to wave a wand and say everybody out there in the world who's not regulated by the CFTC, I want them to do it this way. That's not the way we think about it. But to be in our regulated space, there will be specific things that we require, and if those requirements aren't met, then I think it's unlikely that we would permit those types of things on the
Okay. Brent, I'm going to ask you the same totally unfair question, so feel free to put it back.
Yeah, I'll give you a totally unfair answer. I just want the bad guys to stop using cryptocurrencies.
Well, I actually think that's something we all can agree upon. I mean, nobody wants bad actors to be in this space. And actually, I mean, I think that's one of the things that if you look at where a lot of the private sector is, like they want more focus on the bad actors, like the frauds, the scams, because that does nobody any good. It's not good for the industry. It's obviously not good for the investors who got scammed. Well, look, I know there were a lot of questions in the keynote, so I assume there's going to be a lot of questions here. So why don't we open it up to some questions from the audience?
Yeah, my question really revolves around how.
Introduce yourself. Just
Yes,
tell-
my name is Armando Soto, and my question really revolves around how blockchain technology and how these cryptocurrencies could actually help you track the bad guys through the use of the ledger technology, whereas cash is not traceable. Cash is, it's fungible. A drug dealer could use it one day and give it to somebody else for a legitimate use the next day, whereas with blockchain, you're able to track those assets, and you could potentially block those assets out of the blockchain. So do you see that as a positive going forward, or have you looked at blockchain as a technology to track bad guys?
Well, so I want to push back on the question ever so slightly, which is actually we're pretty good at tracking cash in some spaces. Because we get currency transaction reports and other things like that. But it's a fair point. There's no question that aside from the anonymity, the blockchain actually provides a remarkable process for tracking transactions. And so to the extent there are bad actors using cryptocurrencies that are recorded on the blockchain, using blockchain technology, there's no question that that is an easier way to track things if you can identify who the ultimate beneficial owner is than lots of other financial transactions.
Maybe the one thing I would add to that is I think one of the things you're seeing is when you can actually know your customer, it makes the job much easier for the government, right? So if you have a spot, whether it's exchange or we saw recent guidance about ICOs having to register MSBs, money services businesses, and therefore do anti-money laundering, know your customer. So yeah, if there's someone in the chain who knows who the person is, like that makes
Yeah,
the job.
and right. The FinCEN has issued a notice in 2013 saying basically, if you play certain functions here, exchanges, for example, you probably are a money transmitter. You need to, states require money transmitters to register, and we impose AML obligations, including know your customer obligations on money transmitters. So, for example, I have a Coinbase account, and I had to submit all sorts of information. It's of no use to me anymore because the Office of Government Ethics can't figure out how they're going to treat this stuff, so I divested all of it. But yeah, there's definitely, we are imposing know your customer obligations, at least on those who touch the United States.
So just a small point from me on this. Part of your question and Brent's answer gets at what I was trying to talk about with respect to the magic wand and what we would require for a registrant or participant in our space. So your point about cash is a really good one. I mean, cash is actually is totally anonymous. And the reason that it's not anonymous in the way that it functions is because you've got a regulatory structure that
Right.
sort of exists around it. And so I don't think, from a regulator standpoint, I'd say, oh, there's a problem with cash because I can pay you money and there's no, I can pay you money, you can accept it without asking who I am, and nobody can know who was behind either side of those transactions, because that cash exists within a regulatory ecosystem that has all sorts of things built into it. So as Brent says, we really can track it really well. And so that's where we're focused. We're focusing on making sure that to the extent that any commodity or anything that comes into our space that we may not be immediately able to tell with nothing else, identity is one part, but there are all sorts of other things that we care about knowing about. We want to make sure that when those enter our space, there are some basic requirements about the things that we would need to know, just as there are in every cash transaction really across the world.
And the IRS is picking up on who they are too. I mean, you mentioned Coinbase. They just won a major lawsuit, so Coinbase has to hand over to the government anyone who's transacted more than $20,000 on the exchange. I imagine that is just growing. That puts a name to a wallet. You funded your account, or you pulled money off of your account onto another wallet. They can now track that and associate that name. So it's pseudo-anonymous is the way I would like to think of it. Very practical.
Trust me.
Hi, my name is Guy Hirsch. So I have two questions, one for Jamie, one for Kiran. So, so Jamie, there's a kind of one of the theories that we've been hearing is that the CFTC might look at FCMs as the vehicle to basically regulate cryptocurrency, providers, and thus make the MSB or MST track kind of obsolete. Does that have any legs? Do you think that can happen without an act of Congress? And for you, Kiran, so my assumption is that Bittrex doesn't have an ATS license. And given recent kind of SEC announcement, I'm really interested in hearing how do you explain the legality of what you're doing in the US, absence of an ATS license, both kind of internally and also to how do you explain that to the regulator?
So I have a very uninteresting answer to your question, which is I can't be specific about any particular things that the agency is thinking about or not thinking about from a regulatory standpoint. What I can say is the question highlights something that we are thinking about, which is what are the kinds of regulations that the CFTC should be thinking about with respect to this area? What are the kinds of things that in a perfect world we think, or from a good governance standpoint, should be part of this legal and regulatory world that may exist outside of our jurisdiction, and so we need to have conversations with Congress or with other agencies or with the Treasury. And so I don't want to be evasive to not answer your question, but I just can't right now talk specifically about anything that the agency is thinking about from a regulatory standpoint. But I can tell you that it's something that we are thinking about both with respect to our regulatory authority, things that may be outside our regulatory authority or different from our regulatory authority, whether it's private activity like SROs or whether it's other things that may actually require legislation from Congress.
And I guess for your question to me, just for clarity, ATS is alternative trading system. It's an SEC-regulated exchange where you could trade theoretically tokenized securities. There isn't one out there today as of yet, but as I think Bill mentioned at the keynote, right, Bittrex spends a lot of time, energy, and money to ensure that we don't list tokens on our platform that we can consider securities. So we work with the token teams themselves. We require the token teams to provide a sort of memo or opinion from US-based counsel explaining why under this Howey Test that we talked about, the token is not considered a security, and we have our own lawyers review that as well. So it's a fairly rigorous compliance process, and it's one of the things that we think separates us from a lot of the industry.
Hi, my name is Eric Weiss. I have a question for Brent, if I could. Could you comment a little bit on how Treasury is thinking about Fed coin or digital dollar and where that stands? And then in addition to that, kind of to the point you were making earlier, if it is something that's being considered, does the fact that the U.S. government would essentially know every transaction that's occurring with the U.S. dollar with certainty infringe on any existing privacy?
Well, I don't think we've seen a lot of reason to have a Fed coin or a digital dollar. I mean, in a sense, the dollar already is digital. Almost all transactions are already digital. But in terms of setting up a separate Fed coin or digital dollar, I don't think we've seen a need for that. I mean, the places where you see sovereigns doing that tend to be places like Venezuela, where there's a reason they're doing it. And I don't think we have a similar urge. And if we did do it, you would be right. There would be privacy issues.